It is said to be a historic judgment wherein Supreme Court has put the sedition law on hold. Now, what do the legal expert have to say about it? With us, we have Special Public Prosecutor Advocate Ujjwal Nikam, sir. So, how do you take and what is your first reaction about today's judgment?
It is indeed a very good order, speaking order passed by the Supreme Court while staying the operation of Section 124 of IPC and thereby restrained all the state governments and the central government to register any offence under sedition, that is under Section 124A. Of course, this interim stay will subsist till the final disposal of the petition in the Supreme Court. But the important thing is that the central government has, in principle, has accepted that the provision of this law were misused by the certain governments, and therefore they have suggested certain modification and amendments in order to check and counter checks the misuse of the provision of law on the sedition. And the first step which the central government has suggested, that the prior permission of Superintendent of Police is needed before registering any offence under Section 124 of IPC. I think, of course, the central government has not yet given the final draft, but the Supreme Court has stayed the operation of Section 124A.
Do you, when you said that certain governments have misused, do you mean to say only state governments or union government as well?
All the state governments, including the central government also.
Do you need, there is a need for reviewing of this 124A?
That is the precise question before the Supreme Court, whether the Supreme Court would like to quash the provision of Section 124 of IPC, or the Supreme Court would like to accept the modification which have been suggested by the central government in order to put intact the law on the sedition so that it should not be misused by any government.
What about those cases that have already been registered under this 124A?
Frankly speaking, the interim stay has no retrospective operation, and therefore whatever the cases which are already been registered under this act, that is under 124A of IPC, they will still subsist. The only thing is that the concerned people will require to go to the court again, the concerned session judge, and to agitate that they have not committed any offence under law of sedition, and they will, whatever the relief they would like to have, they have to convince the court, and the concerned judge will grant the relief if at all the case fits in that corner.
Squashing is the answer, or amendment will solve the problem?
It is for the Supreme Court decide and not me.
As a legal expert?
I can't say.
So this is Advocate Ujjwal Nikam, who has given his say that he has appreciated the move about the Supreme Court. With camera Gopal Harne, this is Pankaj Khelkar in Pune for India Today.